Alrighty, as you can tell in the background, I'm babysitting my little new grandbaby. Alright, so again, as usual, this is just We the People News, and we just never look straight forward. Alright, little one, hang on. Give me a second. There you go. Alright. Is that better? Maybe? Alright. We don't never look straight forward. We always look around us, be able to protect ourselves by any means necessary, people. Okay? And this is one of the documents that you ought to look up. And he'll give you information on that. Kidoki. So, without further delay, due to the little grandbaby, I'm going to go ahead and start the process.
The state court judge is barred.
There we go.
Claims against him are barred from judicial immunity.
Let's get a bottle.
Again, nothing could be further from the truth. The court says, the Supreme Court says, there's only two exceptions to absolute judicial immunity. Actions not taken in the judge's judicial capacity and judicial actions taken in the complete absence of all jurisdiction. Well, wouldn't you know it? What did we challenge in state court? What do I tell you guys to challenge?
Jurisdiction.
Boom! We challenged jurisdiction.
Mm-hmm.
I mean, in this woman, she even states in her report what we did. What do you think a threshold issue is? A threshold issue.
A jurisdictional issue.
Exactly, right? Let me ask you this, Justice. What's a threshold? Like in a constructions term.
Like something that encompasses the maximum of something, like as far as it can go, right?
Yeah.
The doorway, right?
It's a doorway.
Yeah.
Right.
Yeah, they always talk about, crossing the threshold.
Oh, yeah.
To your home.
Carrying your bride over the threshold.
Exactly, yeah.
Right.
Carrying your new bride over the threshold, yeah. That's exactly what it is. So if you're challenging jurisdiction, that is a threshold issue. It prevents the court from moving forward until that challenge has been properly proven on the record. So this moron, and I don't have a problem calling her that because she is not worth the time the court is giving her. This moron states in her report.
Now.
Well, you know how I feel.
You know how I feel too.
I'm not saying she's not worth. Hey, she can do whatever she wants with her life. Just stay the crap away from my cases.
Right.
She talks about how in the amended complaint that that the state court judge didn't follow this, denied threshold issues, and she says that these are all judicial in nature. Well, guess what she conveniently omits? Well,
Did you say admit or omit?
Omits.
Okay.
Right here.
Okay.
I said Romero conveniently omits the fact that the threshold issues presented before the municipal court were jurisdictional issues noted in the amended complaint at paragraph 98. And in paragraph 98, it says the issues presented were in personam jurisdiction, subject matter jurisdiction, and other jurisdictional issues. I said, additionally, it's noted of the fact that the prosecution failed to object to these jurisdictional challenges in writing prior to the hearing and was stopped from bringing his objections. He couldn't bring them up. The rules don't allow him to, but he did. This is the power we the people have, you guys. In my footnote here, I state that he supported his amended complaint with a sworn affidavit, verifying under the penalty of perjury to the truthfulness of all of his allegations, which have gone unrebutted thus far. So under this standard, well-pled allegations and a verified complaint must be taken as true and factual. Okay?
And this is happening nationwide in these courts.
Everywhere. So I'm going to skip down here. She also brings up this ridiculous doctrine called the Heck Doctrine. Just for everybody knows, the Heck Doctrine is one where you're convicted in a state court and then you file a Title 42, 1983 civil rights complaint challenging that conviction. The Heck Doctrine prevents that. There again, how does that doctrine apply when there was no conviction when we filed our complaint?
Yeah, that's interesting.
It makes no sense whatsoever.
Mm-hmm.
I talked about the quasi-criminal action using administrative law, and we're going to talk about this today a lot.
So, James, you rebut that heck doctrine, right?
I did.
And do you ask for evidence when you rebut these?
Well, yeah, I mean it's right here. So I say it right here. How is it that actions that took place 7 months after the timely filing of an amended complaint should have any bearing on the outcome of a motion to dismiss filed 7 months later? It's absurd to believe that equal justice under the law would be served for this honorable court to adopt this report of recommendations under these pretenses. I mean, am I wrong?
No, my question was, do you put the burden of proof back on them?
It is. The burden of proof is on the moving party. The moving party in this case is the defendants. They're seeking to have our case thrown out.
Right.
So the burden of proof is on them, and I touch on that here in a little bit.
Okay.
Okay. The next thing I touch on is the prosecutor. His name is Defendant Robinson. He brought a quasi-criminal action against the plaintiff using administrative law to supersede his constitutionally secured rights. All right. We're going to talk about this. Okay. Here's where I really hammer, and I think this section here is the section I'm most proud of, where I hammer this magistrate judge. It's section D. It says, oh, and by the way, just so everyone knows, this document was posted in the Affidavits 101 group on Telegram. It's under this title heading, Plaintiff's Objection to Magistrate Judge's Order. You guys can all get a copy of this. You can download this. You can plagiarize this as much as you want. Be my guest. Okay? Section D. I'm going to read this one because this is super important. Because again, nobody talks about how facts get before the court. And I say Romero's lack of understanding of how facts get before the court. Romero also proves to be an embarrassment to this court with Romero's lack of understanding on how facts are properly presented to the court. Any fact that is presented to the court in brief or argument must adhere to the rules of evidence and must be sworn to by a witness or someone with standing who has personal knowledge of the situation. And that's coming from the Federal Rules of Evidence, Rule 602. With this in mind, Romero's understanding of the use of affidavits to support the amended complaint is crucial in any summary proceeding. Just so you guys are aware, a motion to dismiss is a summary proceeding. They're asking the court to summarize that, hey, you guys don't have a case. So here's what I say, to wit. The sound principle is that unsworn allegations in unverified papers may be pierced by affidavits that measure up to the evidentiary requirements of Rule 56E, that's the summary judgment rule, in defeating a motion to dismiss under Rule 12b-6. If the adverse party does not so respond, the court cannot lawfully consider the papers as they are presented in an improper format and are a nullity. See Trinzi v. Pagliaro. There's that case.
All right. So on that behalf, this right here, I would do a video on the courts speaking on it. Well, all right. So somebody else is going to read it. But really what this consists of is attorneys are operating in hearsay. Okay, in short terms.
It is immaterial that the defendant's counsel, whose papers were unsworn by defendants, referenced otherwise relevant authorities. Romero continues her attack on both the integrity of these proceedings by claiming that Brown's sworn, unrebutted statements are not facts but merely allegations. Romero's assertion is too bizarre to even comment on. The question exists. How does Romero think that facts get before the court other than by sworn testimony? And this is one of my favorite cases too. You guys write this one down. Defendant has filed no counter affidavit, and therefore, for the purposes of the motion before the court, the allegations in the affidavit of plaintiff must be considered as true. Federal Rules of Civil Procedure, Rule 9D. That case is Group v. Finletter. It's Finletter. And by the way, that came out of the district court out of D.C. That's a very liberal court. Romero continues to advocate on behalf of the defendants to the great prejudice of Brown by presuming facts that are not in evidence or in the record. Her assertion that the defendants are entitled to qualified immunity is too bizarre to even comprehend. Romero's acknowledgement that the state court judgment is facially void is painfully evident in Romero's own paper. To wit, that Brown properly challenged the state court's jurisdiction of the subject matter, among other things, a challenge that went unanswered and unopposed by the moving party in the municipal court case, defendant Woods Cross City and defendant Robinson. Romero's erroneous declaration is that the unanswered jurisdictional challenges of Brown proves nothing, where the rule of law provides quite the opposite. Okay? This is a really important section here. The Federal Practice and Procedures Manual, Section 3522, clearly establishes that once jurisdiction has been challenged, it is presumed that the court lacks jurisdiction unless or until the evidentiary sufficiency is provided and submitted to the record. The presumption is that a court lacks jurisdiction on a particular issue until it has been demonstrated that jurisdiction over the subject matter exists. The facts showing the existence of a jurisdiction must be affirmatively in the record. If jurisdiction is challenged, the burden is on the party claiming jurisdiction to demonstrate that the court has jurisdiction over the subject matter. The limits upon jurisdiction must be neither disregarded nor evaded. The requirement to submit admissible evidence upon the record proving jurisdiction once it is challenged is mandatory. The Supreme Court of the United States, as well as lower courts, have consistently reaffirmed the requirement that once jurisdiction is challenged, those who claim it must submit the evidence to prove the validity of the claim. Any questions on that, you guys?
Did
Erica, Justice?
I was muted.
Yeah.
No questions, but it's damning.
It is.
So,
It's-
but
it's-
here's like my main thing that I keep thinking. These magistrates don't just come out under a rock somewhere and start doing this sort of work, right?
Are you sure?
Well,
To me, she's
Again, people, not a sovereign citizen thing.
either, just totally unknowledgeable and doesn't know the law and is completely incompetent, or perhaps she's operating by a different set of instructions than the ones that we are.
well, here's the thing. Okay,
Well, yeah.
these magistrate judges, oftentimes they are just barely coming off of practicing law.
Again, we're not attorneys. We're not making legal advice. This is just a learning video. All right?
How many lawyers do you know that actually submit verified affidavits with their complaints or with any documents that they file with the court?
Yeah, check with your attorneys. See if there's affidavits. Right? Even with judges, when they're in contempt of court, you tell that judge to put an affidavit under penalty of perjury and give it to another judge. Because now that one particular judge is making a claim. Right? Now he become a claimant. He cannot be judge, jury, executioner.
They skirt these little issues, and they hope that the court will just go ahead and render judgment in their favor. So again, the problem is, if I want the court, if I'm moving the court to issue a judgment in my favor, I still have to grant the court the power to do so, right? So if I'm the plaintiff and I submit my complaint and I support that complaint with an affidavit sworn under the penalty of perjury that everything in my complaint is true, I have given the court the power it needs. But if I'm the defendant and I'm challenging the validity of that complaint, and all I do is I have some Joe Schmo shyster submit a motion to dismiss, and there's no affidavit from me, one of the named defendants, have I given that court any power to grant that motion to dismiss?
So he has to rebut it point by point,
It does.
in addition with his motion to dismiss. So
Yeah,
to
and this
you-
this is exactly what I'm going to get a freaking ruling on this. This is the challenge that I'm taking. It's like, hey, why is it that we put our neck on the line, but they're not supposed to? And how is it that when they didn't put their neck on the line, by swearing under the penalty of perjury that everything they did was above board, that they did everything according to the rules and due process rights of the Constitution, how is it then that they're not willing to submit an affidavit supporting that, or even depositions for that matter? I mean, we already know the answer.
Well, because they're trying to get away with it.
Yes.
Path of least resistance.
Yes.
And they'll keep doing it until they get called out on it.
Yes.
I'll tell
Yes.
you, after Romero reads this, she's gonna remember this smiting.
Oh, I sure hope so. I want her to
Yeah.
remember this.
Right,
I mean,
yeah.
Joe brings up a good point here. She said, in my quest of jurisdiction in my case, I have found that I have done this to hundreds of people. Yes, they have. And what do you call that? This is called racketeering.
Racketeering.
Exactly what this is.
So, James, do you add RICO charges in there then?
You know what? You absolutely can. And I haven't. You know, I'm going after them for this. But you can bring a RICO claim against these people. And here's the thing, you guys. When you bring a RICO claim against these people, the Supreme Court has stated that you have the right to go after them as a private attorney general, and that the Department of Justice is required to open up an investigation and to file a criminal information against them.
Could you explain real quick what RICO means for?
Yeah, it's racketeer influenced corrupt organization. It's basically any organization that is extorting money from people under the color of law.
Knowingly.
And knowing what they're doing is wrong. Okay? So what I've got up on the screen now is
Family
where
court.
again we talk about, the judgment that was issued was a void judgment. And it has no bearing whatsoever on anything. Again, like I said before, when you challenge jurisdiction in any of these state courts, it stops at that point. Anything they do after that means nothing. Absolutely nothing. Okay? I'm not going to go through all of that stuff here for the interest of time. I talk about how this judge's failure to follow the federal law and the rules of procedure, the appearance of fairness has been lost. I can't trust this judge anymore. I
Right.
just can't. So I talk about here how this is the one that I can't understand this. It states under this rule that when a magistrate judge is assigned, they must promptly conduct the required hearings. So my question is this: what is this court's definition of promptly? Because it's been previously noted, we filed a document 7 months later, she
Months
finally
ago.
did something. Is that
Yeah.
prompt? It doesn't seem prompt to me.
Yeah, it would be a great question.
Yeah. Secondly, under this rule, it states that a record must be made of all evidentiary proceedings. Where is this record? Because I can see nothing. So are we to follow the rules as the Supreme Court states that we're supposed to? Oh, you pro se people, you have to follow the rules, but we can just pick and choose whatever we want.
Exactly.
That's not how
So-
this works.
James, would this be considered a notice to them?
It is.
If then later you are following up with a RICO charge, because now they are knowingly continuing to move forward in a way that is not honorable.
Yeah, I put it on the record. So,
Do they ever claim deniability, like plausible deniability? It would seem like really weak to be in a position if they could claim something, but even so, this is the notice. There is none.
yeah, no, I don't know that they can. I really don't think they can. There's no plausible deniability here.
I would think so, but
Not after that sort of a light bulb moment for Romero.
no.
well, prior to this is what I'm saying.
Oh yeah.
I don't know. I don't know how they can. I mean, they try, but I just don't see
That's
how
what I'm
they can.
saying. Do they try to do that type of
No.
thing?
Yeah, all the time.
Because it's
All the
so
time.
weak. Absolutely.
It's just a weak. Their position is weak. They don't have a leg to stand on. They don't.
Okay.
No.
So bills of attainder.
Yeah, let's talk about bills.
Alrighty, people. Diesel with People News. Till next time. Bye, y'all.